welcome. Glad to have you here for another Sarah National session. My name is Jenny Anchondo, and I am here each and every week as your host and moderator and sort of facilitator of the event. We have part two. I love a two-parter because we get to go in deep today. We have part two of legal ABCs for your business. So I'll get into that in just a minute and remind you of who our esteemed speaker is for the day. The other thing I'm telling you twice too, because it's a big change starting next week, is that we are changing the time for our sessions starting next week. So the beginning of November, first session of November, we will be doing this same session that we do each and every Thursday at 3 p.m. Central Standard Time. So we're hoping that gives some people a chance to get more settled after lunch. Perhaps you're coming home for the day at that time. We're trying out that 3 o'clock time slot. So I hope that you are able to make an adjustment in the calendar and still continue to join us at 3 o'clock. Now, our guest for today is Mark Vasquez, who's an attorney partner and head of the Texas desk for DeForest, which is a law firm with more than 80 attorneys. They're kind of everywhere, you guys. They're in Dallas, San Antonio, New York, Mexico City, all across Mexico, actually. And for the last 20 years, he has been at it in the law profession. His practice, it encompasses many different avenues, including corporate, cross-border transactions, finance, international business, real estate, tax law. And I know so many of you work in those industries. And so this is really valuable information, or maybe, are aspiring to work in those industries. So he really brings a lot of knowledge with him. He has broad-based business transactional experience focusing on complex corporate and tax matters with an emphasis on cross-border transactions involving a wide range of companies doing business in Mexico and Latin America. Hello, is there a more perfect person to be able to speak to us today? I think not. He also helps out U.S. and foreign companies in the expansion of international operations through branches, subsidiaries, and representative offices. Listen, he walks the walk, talks the talk. He was really helpful last week. If you have not seen part one, part two will still make sense, but I want you to know that if you missed last week, his session is already out on Sarah National's YouTube channel. We'll post the link to that at the end of this session so that you can click on it and get a hold of part one and be able to take notes and everything like that. All right, I will mute myself during his presentation so that we can all be here taking notes. As you send questions, I'll take those down. And when he's done speaking, then we can come back together and get those questions answered. All right, Mark, we are so ready for you. Take it away.
All right. Thank you, Jenny, for that introduction and that welcome. Uh, Good afternoon to everyone. Today, again, here I am. And, we're going to go through our second part of legal ABCs. And as I mentioned, previously, it's not to make you an expert, in this type of fields, but to give you a good foundation and a general background as far as, some of the things that you need to be aware of when you're, in your business, starting a business, or, you're trying to transition into, being an entrepreneur. So it's one of those things where, it's just something to give you a good foundation, and at the very least, where to go look, or where to go ask, or if you have those questions, you can go ask, professionals in that area. So I'm going to share my screen here, so we can get started with our presentation today. And here we go. And this is what I want to talk to you today about. It's going to be basically a contract basics, because that's something that we deal with on a day-to-day basis when you're in business. The human resources aspect of it, handling legal claims, and basically, collections, because everybody wants to get paid, because that's, part of being business is, making money, right? So that's something that everyone always wants to know. And also at the same time, if you have any questions, just please feel free to ask me, and Jenny's gonna assist with that, because I don't want not ask me those questions or forget, because take advantage of the situation where you are right now, and being able to ask a lawyer anything you want as far as your business, or business questions that you may have. So that's actually a pretty good deal for you today. Looking at this presentation, when we're looking at contracts, and here in the US, this is something that always comes up, is are contracts, when there are verbal contracts, is that actually, enforceable? And they are. Oral contracts are enforceable. And that can be good and that can be bad because sometimes, maybe you want to go into business with someone and you're discussing the terms or discussing the business and you both come to an understanding and that can be an agreement even though maybe it's not very detailed and you just talked about it, but that can be an agreement. And one of the things before I get into that, I want to talk to you about this case, this lawsuit that happened between two investment funds. And I'm not going to get into the big details and bore you with all that because I try not to do that. But it was the things where the principals in these investment funds were texting back and forth about, doing some type of joint venture and investing in this project. And they were going back and forth on it, with terms, details. And it openly, at the end, it kind of stayed open ended. And one of the investment funds went ahead with the project and the investment, and they were successful, in the return on the investment. When the other fund found out, they actually sued the investment fund and said, "Hey, give me my part because we had an agreement." And the other investment fund said, "No, we didn't have an agreement. You didn't provide any capital. You didn't provide any investment. We were just texting back and forth between the principles of it. And no, you're not entitled to any of those returns on the investment on the profits." Ultimately ended up in litigation, and this case was based out of Texas, and it went to the Supreme Court, and it ended up where there was a partnership based on those texts that were going between the two principals of these investment funds. They did find to be some type of partnership that was in place. So ultimately, the the investment fund that actually did the investment took all the risk, had to pay 50% of the profits that they made on that project to the other investment fund. So the question would be, if they would have lost, their investment, would they actually been able to reclaim it and recoup it from the other fund that did not? And based on the reasoning in the court, they would have been able to. So that's an extreme example of how, a text message is between parties, or emails or just a phone call or just conversations can end up into a contract. So how would you avoid that? Well, one of the things, if you're, now in these days where, we're texting, or instant messaging or emails, or phone calls, how do you avoid, going into some type of, oral contract? Well, for instance, in this specific example, and this is something that can be used, if you're going back and forth and you really don't have an understanding, are we in an agreement? Are we not in agreement? If you're not, one of the text messages should go back, okay, we're not in agreement, or we're just something as simple as that, or an email as well. Uh, if you are in agreement, you can text back or you do an email. Let's put all this in writing now. So when you say those magic words, is about putting it in writing, then that says, okay, we're gonna formalize some type of an agreement where all the details are in place. And these text messages and these conversations or these emails that go back and forth are not necessarily going to be part of the contract. It's going to be what's on the paper. And that's why it's important to have that written contract, because it avoids all the discussions, all the text messages, any instant messages that are going back and forth, but it actually allows you to put the details in writing and not allow anything else that was discussed to come in. And usually, when you do this type of an agreement, there's something in the agreement that we always put that says, anything that was discussed previously, or, any issues that were mentioned are not part of the agreement. It's only what's in the contract. So that kind of takes away any misunderstanding. And that's what you want. Basically, the agreement is, and a written contract is, so you can know what you're getting yourself into, what your obligations are, responsibilities, and basically how the parties are going to treat each other in this agreement. So that's why it's important to put it in writing, because like I said, here in the US, oral contracts are accepted. So, it kind of leaves the interpretation wide open if when it's just between, texting and emails and just, phone calls. So that's important. But some of the other issues that come out is, there's always damage limitations that you want to consider. You don't want to have, if there's a breach of this agreement, have open-ended damages where it can be, astronomical as far as, what you may have to pay if there's a breach, especially if one of the parties is at fault. and don't think they're in fault. You want to limit that. So there's clauses, provisions that you can limit the damages in an agreement. And something that we're seeing now is more contracts going to arbitration provisions or clauses, as opposed to saying, okay, I'm going to file a lawsuit and we're going to go through court, which can be very time consuming and very, exhaustive when it comes to, money wise, as far as what you're going to spend. Sometimes we go through arbitration, which is a lot faster. And through arbitration, there's certain provisions that you put in there that, each person selects an arbitrator, and then there's one that's appointed independently by the arbitration association, and that's how you present your case. And in those situations, they're binding. It's like whatever they decide, that's what's going to be, and you don't have to go to court to actually get it, approved. That's what it is. And then you're always going to have a liquidated damages, and liquidated damages just means, how can I basically monetize my damages? Because sometimes, they're not clear as far as what my damages are. So how am I going to monetize that damages? So sometimes, those provisions, and some of the most important ones when it comes to a business or an entrepreneur starting is your lease agreement. That's like, I'm going to go rent space, because that's one of the maybe the first ones you're going to come across with as far as your lease agreement. And those lease agreements can be very one-sided. So that's always important to look at that and make sure that, when you do these agreements, that you're not personally going to be responsible for any of the business obligations. You want to kind of maintain that separate. Because sometimes most of these agreements, when it comes to your commercial leases, they want you to have a personal guarantee. So what that means is your business fails, then they can go after the owners of the business to respond for the breach of the lease agreement. So there's a lot of clauses that you can put in there as far as to prevent that from happening, even if they do want you to have a personal guarantee. Sometimes, one of the basics is to limit that if you want to terminate the lease, that there's some type of liquidated damages that says, okay, I'm going to pay you this and you let me out of the lease. And like that, you're not responsible for the whole lease. Maybe you're just responsible for that uh, small part of money that you have to turn over, and you're out of the lease, and they can't sue you for, maybe you still have 5 years remaining. They don't have to sue you for that. I mean, you're out. So that kind of alleviates that obligation. So that's an important situation that you always want to face. That, and when you want to look at these leases, that's one of the things that you want to consider. How can you terminate it without breaching the lease? So that's important. And also, when it comes to, the ability to bring a lawsuit, in these contracts between companies and business partnerships, you know, you always going into these arrangements with the thought of, okay, we're going to be successful, we're going to do well, and we're going to, comply with what we agreed to. But you also have to consider that that may not always be the case, that maybe, their partnership or the contract is not really going to work out. So how are we going to, unwind that? And that's something that you want to consider when you're, fulfilling these obligations and drafting these contracts, is ultimately, if this doesn't work out, what's going to be the downside between the parties? Are we going to be out money? Or am I going to have to, be obligated for the debts of the business, or not? How is that going to work out? So that's some of the issues that you always have to consider, when you're drafting these contracts. And it's just, a lot to consider sometimes. So that's why it's always important to look at the situation that you're in, maybe, what agreement you're going to get into, and does that meet your needs? Because a lot of times they can be really, really one-sided, and it obligates you when you don't need to be obligated. Because, out there, they'll try to take advantage of you as much as they can, so you want to basically, have an equal say in how this contract is drafted. And that's really important. Going on to these other contract terms that a lot of you is, there's liability limitations that we talked about, limiting your damages, the warranties. If you're selling a product or you're buying a product, there's warranties that go along with it. And depending on the state that you're doing business in, sometimes these states require to have actually more broad warranties and more detailed warranties than other states, where it can just be a general warranty. So it just depends. So that's something that you have to consider depending on the state that you're doing business. And one of the important ones is the indemnity provisions. And this basically says if one of the parties causes some type of damages, then and they go after the other party, then the party that caused the damages is basically going to be responsible to respond, for those types of legal obligations. And if you're not the responsible party and you're dragged into this, then that other party has a responsibility to protect you, to indemnify you for whether it's a lawsuit, whether it's damages, whether it's any type of legal obligation, but you don't want to be responsible because you didn't cause it. You want the other party to stand up and basically, you know, take over this indemnification to protect you. Because if you didn't breach the agreement, then someone else has to do that. And the other one is the intellectual property protections. I know we talked about that the last time we talked, but a lot of these contracts depend, especially when you're getting into business with maybe you're going into a joint venture or a partnership with another company, and you're bringing something to the table, and they're bringing something to the table. And a lot of times, it can be intellectual property, which can be your trade secrets, which could be, in this case, if it's patents or it's way of doing business that they're protected to you individually, you want that to be protected. So if ultimately, the partnership terminates, a joint venture terminates, a project terminates, you don't want the other party to be able to take your intellectual property and use it for their own benefit and their own gain. It's when it terminates, it stays with the party that brought it, and no one else can use it. And that's a way to protect your business. So that's also very important when you're looking at this. And as part of this intellectual property, sometimes you're getting into, maybe negotiations on a project or on any type of dealings that you're going to have. So you want to have some type of non-disclosure agreements, because you are going to disclose maybe sales figures, pricing, vendors, all that, customer list, but you want them not to be disclosed or used because you developed that. So that's something to also, include in these contracts, depending on the type of contract that you're trying to negotiate. And the venue is another important one. And venue, by that means, if something goes wrong, where are we going to decide, what the ultimate resolution is? So if you're doing business between a Texas company and a California company, ultimately, where are you going to decide that if there's a dispute, where is it going to be resolved, in a Texas court or a California court? So that's something also important, because sometimes, maybe you do business internationally, and you're entering into agreement. Where do you want this to be resolved? Do you want somewhere where you're more familiar with the way, the legal system and maybe some of the laws work when it comes to business, or you're going to, another state or another country where you just don't know? So that's something that ultimately can be negotiated. And the other part is also like the attorney's fees. Ultimately, depending on the contract, it says, whoever prevails, then they have to pay for all the attorney's fees, for the losing party has to pay. So that's a clause that can be negotiated as well. So that's always good to look at into your contracts. It's really important. Um, Moving on to the HR, and this is something that affects you when you have employees day by day. And a lot of times, everybody has an employee handbook, or they should have an employee handbook, because this basically sets the basically the relationship between employees and management, and just the overall operations of the company. And one of the things you always have to look at when you do these employee handbooks is that they're not a contract, and you want to have a disclaimer that says, this is not a contract, doesn't create a contractual relationship that binds you. You still want to have those at will acknowledgments. And when I talk about at will, that's a legal basically term that says, you're an employee at will, meaning, I can hire you, I can fire you at any time with reason or without reason. And that's something that's for a company, for a business owner, that's very beneficial, because basically you're not going to be tied to an employee that maybe doesn't perform and doesn't do their job, or maybe you need to let go of employees. It allows you to do that with reason or without reason. And that's why it's always important to consider that at will doctrine and not have contracts in your business with employees, because if not, then basically the contract is going to define your relationship and not basically the state law that you're in. And sometimes that can be very detrimental to a business, because under an at will, for example, you can have an employee that works for you for 20 years, and one day to the next, you can terminate them without any obligations, without any legal obligations. And that's really important, from a business standpoint. Same thing with the employee. It can be a good employee, work for you for many years, and they leave from one day to the next without any, recourse. And that's the at will aspect of it. So it has its good and its bad. So it just depends on the business that you're in. But like, again, it's more beneficial to have that relationship as an at will, as opposed to some type of contractual relationship. And the only things that when it comes to the at will relationship is, if you discriminate, then, there is some legal liability, even if you have an at will relationship. Or basically, if you as a business owner are requesting or requiring the employee to do something that's illegal under the law, and the employee says no, and you terminate the employee, then the employee, can come back to you for that because you retaliated because you were asking them to do something illegal. So there's very few examples where in situations where the at will doctrine will not apply. But other than that, you basically can terminate employees, with reason or without reason, or hire with reason. Another thing that when it comes to human resources, especially in businesses that have a lot of trade secrets, you want to have non-disclosure agreements and confidentiality agreements where the employee signs this and says, you're going to be exposed to a lot of my trade secrets, where it can be customer list, it can be vendors, it can be trade secrets that I use in my business. And once you leave this, whether it's voluntary or involuntarily, you cannot use those trade secrets to benefit yourself or benefit a third party. Say you go work for another company and you take that with you and you start, revealing all these trade secrets, then, there's consequences to that. So, that's an important agreement to have as well, is, depending on the business that you have and if it is very intensive when it comes to trade secrets. Not of also harassment. So, as when you're employing, there's harassment when it comes to sexual harassment. There's also, a lot of the, maybe it's discrimination based on, your race or national origin. There's those types of harassment. So it's always important to have some type of training to your employees to prevent this, because if this doesn't happen in your business and, there's nothing done about it, um, it has consequences where the business is going to be responsible for any of this type of harassment that's happening there in the business, and no action has been taken care of. And the main thing is, to do some type of training when it comes to that. And you also want to have good hiring procedures, because, there's always questions that you can and you can't ask. And, depending on the interview, you want to have, this checklist of procedures of how are you gonna, you know, hire this person and bring on board or interview them, and what can you ask and what you can't. You can't ask about the age, you can't ask about marital status, about the kids. There's things that you can't ask that are, personally identifiable in that sense. You have to keep it towards the business, the job, and maybe in generalities as far as how the person works or how their attitude is. But as far as personal questions, then that's something that you just don't want to do, because that can get you into a legal bind. And you also want to have like a termination checklist when you do that, because a lot of it is, yeah, maybe I'm terminating somebody, but also did they turn in, any type of documents that they have that may have some trade secrets. And that's something that's really common. They terminate, but they take with them maybe some type of trade secrets with them. So you always want to be able to, have that where they don't have these trade secrets. Maybe you're terminated, maybe their email addresses or access to those types of, databases that you may have. The thing that I see a lot now is these wage and hour issues, because a lot of businesses, they say they have no employees, they only use contractors, but really the contractor is treated like an employee. And there's a lot of audits with the Department of Labor, the states also do those audits, and the IRS does audits, because basically they want to know, is it really an independent contractor or is it really an employee? And you're just classifying them as contractors, so you don't have to do the payroll tax issue, or collect the payroll taxes, and do the payroll tax returns and send them out. And that's something there's a lot of those audits happening. And when they do these audits, they look at these factors, and a lot of factors have to do with control. How do you control this person that's working for you? Because on a contractor, you can't control the contractor. You just give them the work, give them the project, and they do it based on the parameters that you set. You can't control the hours they work, how they do it. It's basically saying, you're doing this and I'm going to pay you this much, and they agree, and then you turn in a certain time. That's a contractor. It's independent. They can go work for other people. An employee is not that. An employee, you're controlling basically how they work, when they work, how they do the work, how they get paid. And basically they have an expectation of, If I'm hired here, I'm going to work and you're going to pay me. A contractor is not. A contractor's expectation is if I do the project, then you'll pay me. If not, I'm in breach of the agreement that I have with you. So it's about control. And like I said, if you do undergo one of these audits, whether it's at the state level or federal level, and it's found that yeah, your contractors are not really contractors, they're employees, then there's back taxes you have to pay and there's fines you have to pay, and that can be really exhaustive. And it can be really detrimental to a business. It'll basically can close your business. And then the other part is the exempt and non-exempt, and we're talking about overtime. And because you want to classify everybody as being a person that, okay, we're not going to pay them overtime because they're really like a manager, or they're not really like an hourly employee. Well, lately, it's very difficult, to classify that, because now the Department of Labor is going now towards where considering everybody is entitled to overtime. They're going towards that, and there's only certain positions and certain situations where they're not. So that's something also that if you have these issues or you have these concerns, you have to go get some good advice, because every situation is different, and you don't want to misclassify these employees, and maybe you're not paying them overtime and then when they should be receiving overtime. So it's really important, because like I said, every situation is different. There's not one size that fits all. So it's all depends on the business and how the work is carried out and what work they do. Because again, you don't want that issues to pop up in your business, because it can be very detrimental. I've seen it where these issues have actually closed businesses down, because the penalties and the back overtime is just immense when it comes to that. Um, Now I'm turning over to how to handle a legal claim. And this is important because, as we're famous here in the US for lawsuits, for the litigation. If you're in business, sometimes I'll tell you this, it's a business tactic sometimes. It's not necessarily just because you want to file a lawsuit, it's because it's a way to negotiate sometimes. It's a way to negotiate to get out of a contract. It's a way to negotiate to get out of a deal. It necessarily mean that maybe there is some damage that was done, or there's something that needs to be redressed. It's sometimes it can be used as a business negotiation technique as well. But one of the important things is you have deadlines that are imposed in these legal claims, in these lawsuits, and here in the US, the lawsuit has to be given to you in person. And if they don't give it to you in person, they have to jump through a lot of hoops. The other party that's suing you has to jump through a lot of hoops to be able to say, okay, I couldn't deliver it to the person, in person. I have to have an alternative way to serve this person to handle, basically give them the lawsuit, which could be maybe living it at the place of business, maybe posting it at the doorway, maybe giving it to another person that's there at the business. So, those are hoops that they have to jump to, but if not, they have to give it to you personally. And if they cannot, they have to basically demonstrate all the efforts that was put into trying to locate you and give you this lawsuit. And ultimately they exhausted all that. And then there's other avenues then a court can approve to be able to basically notify you that you have been sued. But once you are served with a lawsuit, they do handle it to you personally. It's very important that you have to answer that lawsuit. And by answering, it doesn't mean, showing up in court. It means by, through an attorney, filing a written response to that lawsuit. And most times the responses are not very detailed. It just depends, it's just a general type of denial. And by that alone, that protects your rights. That'll protect basically you being able to go into court and basically fight it out. Because if you don't answer this lawsuit within the period of time that you're given to be able to respond, then basically you lose automatically without even having to answer. So somebody can sue you and say, you owe me $1 billion because of whatever, you breached this contract, even though it's not true. And you don't answer that lawsuit, guess what? They're going to get a judgment on you that says you owe $1 billion, even because you didn't preserve that right to be able to, defend yourself. So that's something important. It's just the very least you have to answer the lawsuit, because that'll protect your rights without having to lose, any of that. And it's always important, like I always say, it's always important to consult with an attorney, because they're going to be able to give you the, what rights you have, what obligations you have, the timelines, and basically to protect yourself. And a lot of times is you have to prepare the events that happen, because you want to be able to have something fresh in your memory that says, okay, this is what happened in this situation. I didn't breach the agreement, and this is why the other party did this and that, and these are the witnesses to it. And that you want to preserve that, because that's what's going to defend you, which is the evidence, which is a lot of times it's documents, a lot of times it's emails, it's text messages, it's call logs, it's witnesses. And there's a big old cottage industry here in the US when it comes to e-discovery, which means electronic discovery. There's companies that attorneys hire and retain, that all they do is, when they're in the middle of a lawsuit and there's maybe a lot of electronic communications, whether it's text messages or emails, they go in and they preserve all this evidence. They'll go into the computer servers, they'll go in to preserve all this evidence and put it in order, and basically have it there to be able to be able to assist in defending or prosecuting a lawsuit. And that's a whole cottage. There's companies that just, that's all they do is they go in there and they just preserve all this evidence, and they put it in a way that it's easily identifiable, easily searchable in these databases. And this happens a lot in the technology litigation, in patents and trade secrets, because it's a lot of technology and electronics and software programs, and especially when it comes to patent litigation, and they preserve all this evidence. But it's also used in a sense where, when there is a lawsuit and there is communication going back and forth via email or text messages, the other party during the process, that's called discovery, meaning you're discovering the facts, you can ask the other party, send me all your email communications that went between these persons or these witnesses, or between these dates. And that's something you have to comply with, if there's those email communications or there's text messages, and they have to turn that over to you. And sometimes you'll get one of these companies to be able to secure this information during that process and that discovery phase, when both sides can actually discover the facts, information, evidence that the other party may have in their possession. So it's also something really, really important that unfortunately, now that we are in this type of environment now, where everything's electronic, and emails and text messages, all those are going to be part of a lawsuit, if that's something that was used to have discussions, as opposed to just on video conferences or on telephone. So, but there's a lot of products also that are attorney work product that you can't show the other side. So a lot of times it's just organizing and getting everything straight in your documents, because that's something that's going to help you handle the legal claims. But like I said, the most important thing is you have to respond, because if you don't, you lose all your rights. So coming to the last part of it is the collections. How do I get paid? How do I reduce, more likely, the losses, not getting paid? You know, in a lot of the states, there's a small claims court, that has certain jurisdiction. Um, some of them say, anything between 10,000 and below, you don't need an attorney. It's a lot quicker. You can go and just file, and sometimes pay between $100 and $200, and you just go and fill out a form, and you file it there, and they'll basically, set up, a court hearing, and basically you present your case without an attorney. And that's quicker, and it's very inexpensive. And it's a way to reduce you know the money you spend. A lot of times, depending on the state, and you have a company or an LLC or a corporation, they require you to get an attorney, even in a small claims type of court. Others don't. So that's something that you're going to have to investigate, depending on the state that you do business in. Because maybe you can bring the claim yourself, but sometimes you may have to, even if the amount is less. One of the things that works pretty well is in a letter from an attorney, demanding payment. Sometimes that works as well, and that leads to getting paid faster, or maybe negotiating. Ultimately, there's also a lot of collection agencies that'll take a percentage of the amount of collected, and you don't have to go forward with hiring your own attorney. Sometimes these collection agencies have attorneys and they file the claims because they'll say, okay, we're going to take a percentage of the claim and we're going to handle it. And you can assign the claim to them and they will basically file a lawsuit on your behalf and basically try to collect what's owed for you. So that's some of the important things that are out there as well that you can use to avoid the losses. Another thing is depending on your business, on the way you have your contracts. Sometimes if someone owes you money, whether it's another business, a lot of times it's good to use a promissory note because that basically affirms the debt. It basically puts the debt in place. And if they sign it, then they can't go back and say, okay, I didn't pay them because the product was defective or you didn't do something that you were supposed to do. A promissory note, what it does, it says, this is the money I owe, and that's what I have to pay. And it doesn't bring any outside information or outside actions that occurred prior to that into, getting this debt paid. So they can't go back and say, no, they breached the contract or they didn't fulfill the obligations under the contract. It's basically, you owe me this money now, and that's it. You can't bring any outside information to this lawsuit. So a lot of companies do that. They'll have them sign a debt promissory note to cover that debt, especially if it's a sizable amount. So that's something that can be used as well, in addition to personal guarantees. When I said don't do it, but if you're on the other side, you want sometimes a personal guarantee because a personal guarantee, is going to allow you to look at another party for payment. And a lot of times, and there's contracts that do that, or there's separate agreements outside of that provide for these guarantees that allow you to look for other parties to get paid. And that's an important part. And again, a lot of it has to do also with knowing your customers, knowing who you're doing business with, because that's going to allow you to, reduce some of these losses in your business. And, sometimes a loss can be good because it can offset if you have a lot of profits and you're going to have a big tax bill. Sometimes, these losses you can use depending on how you're structured for tax purposes. You can offset those losses, on these profits and reduce the tax burden that you may have. So there's different ways of looking at, reducing the losses, using those losses in your business to actually benefit you from a tax standpoint as well. So that's something, that's out there, and you can go get, more information on that, specifically when it comes to how can I use, my losses in my business because I didn't get paid, to be able to lower my, the tax consequences that I may have. And again, like I said, that's the last part of it, because a lot of things that you want to look at is these strategies for payments. And one of it is bad checks, because I know a lot of businesses, we're getting away from that nowadays. There's nobody really uses a lot of checks. A lot of times it's wire transfers or credit cards, but there are businesses that checks do come back and forth, and depending on where you're doing business, there is whole offices within the district attorneys that handle bad checks. And basically you just have to fill out a form that they can provide, because it's a criminal offense, issuing a bad check or a check with insufficient funds. It's basically a criminal offense. So there's a department in most district attorneys' offices where you can fill out this form, send in the check, and then they prosecute it for you. And it's a criminal, and it's not a civil part. So part of that criminal process, when the check was issued, is they have to make restitution. They have to pay you back based on what they did, because it's part of their criminal process, because it is a criminal aspect. And businesses can also be charged, even if you have a company, they can also be charged criminally, because as I mentioned in the last session, a corporation or LLC is actually a person with the same rights, and they can be charged criminally. So if the comes under a company check, the company can also be held criminally responsible for this, in addition to the officers. So that's something that you can use also when it comes to if you do receive bad checks, even though, we're getting away from that, and most people don't, accept checks anymore. So that's also really important that that's out there. So if you do deal with checks with insufficient funds that customers gave you or other businesses gave you, there's an avenue through the district attorney's office that has that capability to be able to prosecute those checks with insufficient funds, which is something, really good, and it saves you money. You don't have to spend money on a lawyer for that. Here in Texas, we have the, like I said, the small claims court, and most jurisdictions, most states have that as well. and it allows you to, present your case, and it'll assist you in collecting the judgment if you prevail. Um, but like I said, that's the end of my time. But I want to be here more for your questions, if there's any questions that we have, because then we can get into a little bit more specifics and maybe more details, and more into depth, as opposed to my general observations that I gave you today.
Yeah,
Um,
Mark, that was awesome. Thank you so much for putting that together and for, going through all of it. I think that, each person comes with a, different perspective, a different, legal past, or maybe they've never dealt
sure,
with anything in the law before. So we're
sure,
all coming from different
sure,
angles. So I'm just going to shoot you with some of these questions. Some of them may be within your scope of practice, some may
sure,
not, but let's go
sure.
through it anyway. So here's one with regard to that employee handbook you were talking
Yeah.
about. So even though an employee handbook is not necessarily a contract, if there's something in the handbook that has not been provided by the employer, can a suit be brought for damages based on the handbook?
Not necessarily. No,
Okay.
because the handbook serves more as a guide of the relationship, the employer-employee relationship, and not necessarily as an obligation that I have to provide you this, right? Because most of them have these disclaimers in those employee handbooks that said, this is basically, an employee handbook. It's a guide of our policies and procedures, and not necessarily a contractual relationship that I'm obligated to provide you this. So that's why, sometimes, yeah, they say they're going to provide you this and they don't. You really don't really have, a lot of, you know uh obligation as an employer to provide it,
Okay.
and
Okay.
the only thing that sometimes with the employee handbooks, and we talked about that at will doctrine, but sometimes the employee handbook will say, okay, if you violate some policy or some rule that we have, we're going to give you a verbal warning, and then maybe the second offense is a written warning, and then maybe there's some type of, consequence after that, suspension or something like that. Well, if you decide to do that and have that in your employee handbook, then you have to follow that, because if you don't and you terminate someone, then they're going to ask for the employee handbook, and if it has, these steps as far as how to terminate, how to suspend, then, and it was not followed, then that does come into play. Then they are obligated to follow those steps, because they're providing you something that's additional to the at will benefit that just says, "Oh, I'm just going to terminate you." You know, it says we're going to go through this step, this step, this step, and this step before we actually get to that point. And if they don't follow it, then yes, then the you have some type of way to recoup, your job back, or some type of back pay when it comes to that, because they didn't follow what they said they were going to follow.
Understood.
But those are only small situations.
Yeah, no, that totally makes sense. Let's talk about a scenario with a small business. And it sounds like over the course of creating a small business, there are various points when you do need to, make sure you're following the law or maybe use an attorney. Most businesses aren't going to be, when they're just starting out. I don't want to make anybody's business seem, smaller than it is,
Right,
but usually when you're first starting out, you might not have like in-house counsel, right?
right,
You're more
right.
likely going to be hiring
Sure,
somebody out.
sure,
Is that a relationship that should be established before you start your business? Like, hey, I need a guy or a gal for when something happens. I
sure,
say, I'm calling my attorney so that
sure.
you have an attorney.
Sure. I mean, it's always good. And I heard this not too long ago. When you're in business, or you're going to start a business, or you're an entrepreneur, investor, whatever the case may be, you always want to have ABC, okay? Which can be your attorney, right? Your banker, and then it says in Spanish is your contador, which is your accountant, your ABCs. You have to have those three individuals, um, because those are the individuals that are going to provide you with good advice and provide you on a good road for success. And you do want to, you want to establish, a relationship with an attorney, because maybe you won't need one. Maybe you won't have that day-to-day interaction that some businesses do. There's some businesses that do have their in-house counsel because they're just huge and they need that. There's some businesses that maybe don't have in-house counsel, but they use an attorney, and the attorney does work for them constantly. I mean, and I can relate to that, because I have clients that I do work for them every day, and there's some that just come here and there. They have a relationship with me, and maybe I'll do something for them 1 month, and I won't see them again 3, 4 months, or maybe another year. So it just depends on the nature of the business, but you do want to have some type of relationship, or at least, know someone that you've had some type of relationship with, that maybe has an attorney, has an accountant, has a banker that can you can turn to, and part of it is they get to know your business. They get to know your situation. So it's basically kind of like a relationship that you base it on because they get to know your business and they need to know actually, what are the things that you deal with on a day to day, and this helps you with, like you said, you come up with a situation, you know who to call, they know who you are, they know your business, and they can provide you good advice when it comes to that to avoid that. Because, one of the things inevitably you are going to have a situation where you're going to need advice, whether it's, business advice, tax advice, legal advice, some type of situation that arises that you're going to need to have someone to talk to. And you do want to have a relationship with someone. And by a relationship doesn't mean that it's someone that you're calling constantly or using constantly. It's just someone that, you already met, you know how they work, you like them, and they know a little bit about your business, and you can call them for that.
Should they establish that before they have any legal needs? Like,
Oh
hey, I've
yeah,
got my
definitely.
business going,
Yeah,
but I just want to
definitely.
see if I
Definitely.
vibe with you. I'm guessing
Definitely.
that's better than calling with like, oh
Yes.
my gosh, emergency,
Exactly.
somebody
Exactly.
fell and I didn't have a plan in place, or
Exactly. Exactly. And that's something that's really important. And I always like to say it's better to spend a little in the beginning than have to spend a lot, at the back end. Because you don't want to be spending the money when you have the problem. A lot of times I tell people I rather you pay me to prevent issues, so like that you don't have those issues, because once you come to me with the problem, then it's one of those things where it can be very expensive, because you already have the problem when you could have gotten advice beforehand to avoid those problems that can arise. So that's kind of my model to everyone is like, I rather you just not pay me a lot, pay me a little, because I don't want to have to see you when you have this huge problem and you're going to have to spend a lot of money. And I'm not there to make people spend a lot of money. I'd rather you not spend any money on legal issues and just focus on your business.
speaking of spending a lot of money, how does it work when you are working with an attorney or a law firm? When if somebody's thinking, "Gosh, okay, I need to establish a relationship. I'm going to
Sure.
call some
Sure.
attorneys." Should they find out what are some questions they should ask somebody
Sure.
before? Should they find out an hourly rate, or how often are you available, or what should they
Yeah, a lot
ask?
of times is, you know, a lot of times, and this is the question that I get, and I guess many attorneys get is, okay, if I hire you, am I going to be dealing with you or am I going to be dealing with somebody else in your firm? Because most times they want to deal with the person that they retain, that they hire, or they know, or they've gotten referred to. They don't want to deal with anybody else. So that's one of the important questions as well, right? Is who are you going to be dealing with? The other is, how do you handle your fees? I mean, are you project based, like a flat fee depending on the project? Is it hourly based? Is it a percentage? There's a lot of litigation that's out there that's based on a percentage of recovery, and a lot of it has to do with like collections or, percentage. In the business aspect, it's not necessarily a lot of those contingencies. It's more project based or hourly based. But a lot of times is, you want to find all these out first before you need an attorney, and that can be as simple as saying, hey, I was referred to you, I have a business. I mean, I don't have any issues right now, but I just want to maybe sit down and talk to you and see if we click, we gel. And because I may need you in the future and I want to establish a relationship, so I already want to know what you deal with, what type of cases, what type of work you do, and also what the fee structures are, whether it's hourly based or project based or a combination of both. So that's one of the important questions always to ask.
Okay, that's really, really helpful. I think sometimes it can be intimidating to
Sure.
call a law office,
Oh,
right?
definitely.
It's
Definitely.
like, "Oh, I don't even know where to
Definitely.
start. I don't know if I can afford
Definitely.
this."
Definitely.
Is there a certain type of law office that people who are business owners should look for? I mean, obviously, some
Definitely.
places, if they're a divorce attorney, okay, maybe
Right.
not, unless your
No,
business gets really
yeah,
stressful.
definitely. And
But
and
type.
and it's like doctors, everybody focuses on a certain area, and there's good general practitioners that maybe do a little bit of everything, but then sometimes, there's certain capabilities that, you're going to need more someone that just does this every day, on a daily basis, where they know the law and they know it in detail and in depth, and they can give you better strategies and better outcomes, as opposed to just someone that maybe does it here and there, and that's not a bad thing, because sometimes depending on your business, maybe you don't need someone that just, does that every day. Maybe you just need someone that's a generalist that can provide you that. But sometimes, especially when it comes to like, corporate structuring and tax stuff, then you need someone that does that constantly, and that's all they do, because they're going to be real knowledgeable about everything that's happening, and they're going to also know uh, a lot of the persons that they're dealing with, especially like when it comes to taxes, and you have these tax controversies and you're dealing with the IRS. You want to have a lawyer that has the relationships with those governmental attorneys, that they know how they work and they know what the system is, as opposed to just someone. And the other thing that and you brought a good important point, and I always tell this when I do these talks to people that want to do business here in the U.S. that come from another country, is the use of notary publics. Okay, in foreign countries, uh, you know, they're called notario públicos, and they're like a lawyer. They have a governmental post. They have to have degrees. They have to have all these requirements. It's a really important function in those countries. Here in the U.S. we don't have that. We have a notary public, but there's a lot of fraud that happens in this industry, because notary public, as you know, is just a person that's basically going to acknowledge who you are and the document that you're signing. That's it. They can't give legal advice. They can't, do any of that, you know. And there's a lot of people that go to these notary publics, especially when they're starting out, and they'll have them form their company, maybe do their taxes, do immigration work, do all kinds of stuff. And I've seen it happen where they come to me, and I've seen, sometimes they'll do all this stuff for them, and they put them in a bad situation, and they come to me with a problem. And then you have to unwind all that. And maybe they put them into a tax situation that's like, like they shouldn't be in. So that's also, something important, that who you going to seek advice. Do they know actually the field that they're working in, and it's just not someone that's holding themselves up to be someone with this knowledge when they don't, because you want actually to have good advice, and you want to actually be placed in a good position and not in a negative position. So that's also really important when it comes to that.
That is really, really important. When it comes to billing or financing, is it usually a by the hour thing, or is it usually like a chunk, or if you're a bigger business, is it on retainer, or
Yeah,
how
and
does it work?
there's all kinds, and that's something that you would explore, because there's some businesses that have attorneys on retainer, and they pay it every month, and it's one of those day-to-day things, right? There's some businesses that say, okay, I need this project done, and if it's a project based, then the attorney can quote them like a fee for the whole project, and it's a flat fee, so there's no surprises. There's others that say, okay, I'm gonna need a retainer of so much, and it's this much an hour, and with that you're going to get so many hours, and we're going to cap it at that many hours. So it has to be done within that time, and if that can't be done, then you go back and you say, okay, we're going to need more, it's going to need more hours to complete this, or not. So it just depends on the situation. That's something you want to also get up front.
Yeah, this is great for when people are sort of, searching and trying to figure out, okay, who do I want to
Definitely.
partner with? Who do I want to be with? When you were talking about the promissory note earlier,
Mhm.
does the individual create that, or who creates that promissory?
Usually you want to have, there's forms, promissory notes that are out there, but ideally you want to go to an attorney to create the promissory note, because you want to have the right clauses in there. You don't want to violate, the usury laws, which means you can't charge, over a certain amount of interest. You want to have those situations in there. So, there are forms you can use, and a lot of times, folks will get a form note that maybe is created by the attorney, and they use that note in all the situations because it has everything already in there. Maybe you pay up front for that drafting of the promissory note, that's a form, and then you can use it over and over again in different situations. You don't have to go back to another, every time you have a need for another promissory note.
Okay, super, super helpful. Now, what about collections? You were talking about who pays for the bad checks, that sort of
Sure,
thing. Now, when
sure.
you go to do that, is that something that you hire somebody for? Do you navigate it on your own?
Yeah, you can, like, when it comes to the bad checks or the insufficient funds, it's pretty straightforward. You don't need to hire anybody for that. Usually, like on their websites, sometimes it'll have the forms that you can just download and fill them out and send them in or drop them off along with the check, and they handle it, and then just they keep in contact with you. The district attorney's office keeps in contact with you as far as the how the process is going. So it's not something that you have to hire someone to do for you. You can do it yourself, and it's pretty straightforward. It's set up for it to be straightforward, to be able to alleviate having to hire anyone to help you carry it out.
I didn't realize that. I've learned a lot from you. That was interesting. I mean, it's like you got to do the legwork,
Yeah,
but then at
and it's
least.
and it's like I said, now with everything that's online, you can just go to any district attorney's website, and they'll usually have the information on there, and they'll have the forms that you need to fill out.
And with small claims court, if anybody, I mean, I've worked in media, I've been in a million different court
Mhm.
cases myself, but if people have never been in there, can you explain, what in these couple minutes that we have, what
Sure.
that process looks like? Because it gets another intimidation
Yeah.
factor where people think,
And the small claims court, as opposed to, the traditional courts with the attorneys, the small claims court is basically, I mean, they handle like evictions, they handle like the small claims, anything. So you go there and yeah, it's like a big crowd of people. And you do have a judge, and sometimes the judge is attorney, sometimes they're not, depending on the state you live in. Sometimes those small claim court judges don't have to be attorneys, sometimes they are. But it's one of those things where it's basically like you kind of like you see on TV, they're kind of like the people's court, and they show up and they just present, and that's basically it. It's kind of just all over the place and freewheeling. And it is actually like that, except there's no cameras and there's a lot more people in the court. Okay, because there's other people wanting to hear their claims.
okay, I
So
didn't realize
that's
that about the judge. Maybe I
yeah.
can go become a judge since don't
Yeah,
have a law degree.
there's some states that allow it and some states that don't, you know? So that's an interesting. Now when you're turning to, the regular courts where you take a lawyer, and that's something that I didn't mention is that, you know, it takes a long time. It's not something, I mean, right now if you file a lawsuit now, it can take up to 2 years before you even go before a judge or a jury, sometimes even longer. So, and during that time, one, there's a lot of time you're waiting. There's a lot of time you're spending because there's a lot of work behind the scenes that's going on. And there's just so many cases that are filed that it just takes a long time to actually get to the point where actually now you're in front of the judge, you're in front of a jury, and you're actually presenting your case. It can, it's a long time. So a lot of times it's, you know, let's negotiate so we can resolve this as opposed to spend more money and have to wait 2, 3 years to resolve something, because then you forget, witnesses don't remember, documents get lost. I mean, anything can happen. So sometimes, sometimes you do have to do that. Sometimes you do have to go through the process, but sometimes, you're going to save time and money if, you can mediate that. And most all court cases are required to be mediated before you actually can even go before the judge or the jury and present your case. There's mediations, and 98% of all the cases get resolved through mediation.
Mark, you are awesome. Thank you for answering questions from far and wide, all over the place. We learned a lot from you. Thank you so much for the presentation today. We so appreciate it.
Thank you, Jenny. I appreciate you having me here this afternoon, and hopefully I provided some valuable, knowledge to everyone
Oh,
listening.
yes, you definitely did. We were all here learning together. So kudos to Mark for hanging with us for the last couple of weeks. Listen, everybody, big news next week. We are starting at 3 p.m. Central Standard Time. So it's an hour later. Just a slight adjustment. Hopefully get you time to kind of like wrap up your work day, take this little pause, little mid-afternoon break to sort of snack and learn instead of a lunch and learn. It's like a snack and learn, get rehydrated, get ready for the, maybe second half of your day. So Thursday, November 3rd, 3 p.m. Central Standard Time. I hope that you're all subscribed to those Sarah emails. If so, you'll get the reminder that will, when you register and everything like that, you'll get the reminder of the time change. But I just want you to know that moving forward, that is a time change. And then also a little save the date for you all. May 2023, we are already talking about that Sarah National Conference in North Texas. So we hope to see you all there, but I just wanted you to kind of keep that on your radar for coming up in May. All right. The links for Sarah National's programs are up in the chat, and then also the YouTube link, which has Mark's session from last week. If you missed it, I'm telling you, you've got to go back and watch it. Incredibly valuable. Have a great week, everybody, and I will see you next week. Thanks, Mark.
Thank you.
Bye-bye.